What I'm about to do now is a video presentation called Remembering the Civil War. This is something I've been wanting to do for a while. As I've told you before, I've done a lot of research over the years, legal and historical research. All these books you see here are from the Civil War period, most of them are. If you want to understand what went on back then, well, what you want to do, you want to read the writings of the people who lived through it, who experienced it, and it gives you an accurate understanding of what went on back then. See, these are the complete works of Lincoln, the works of William Channing, Boston minister, founder of the American Unitarian Association. He took a very keen interest in public questions and made a lot of arguments in opposition to slavery. He was a very smart man. Cotton is King, the slaveholders. This was published in 1860 in Augusta, Georgia. And these people in here, you got presidents of colleges, college professors, senators, governors, well-respected economists. And let's not forget the Reverend Dr. Thornton Stringfellow. Yeah, he was a very popular minister back then. He was kind of like I guess you could call him the Billy Graham of the South back in his day. Yeah, he was a well-respected minister. And he made extensive Bible arguments justifying slavery back in his day. And like he said, the slave is the master's money. Yeah, got to get that slave out there making wages so I can get that money. Hinton Helper's book, published back in 1856, a North Carolinian, non-slaveholding white who did a lot of research, educated himself, and he proved that the free labor system in the North was far better than the slave labor system in the South. Life and Times of Frederick Douglass. Yeah, Frederick Douglass knew all about slavery. He was one. Yeah, this is his book. Jefferson Davis, the writings of Jefferson Davis. He was the president of the Confederate, Ulysses S. Grant. This is the Institutes of Justinian. This is like from the 6th or 7th century. Old Roman law. Slavery was an institution back then. History of Slavery and the Slave Trade. This was published in 1860. And it traces back slavery from ancient all the way to modern times in that present day. These people did a lot of research. George Fitzhugh, he wrote 2 books, Cannibals All, Slaves Without Masters, Sociology for the South. And here's the American Slave Code, an analysis of the American Slave Code. We're back in 1853, and we always got to have Uncle Tom's Cabin. We can't leave Uncle Tom's Cabin out. So yeah, I understand what went on back during the Civil War. I understand what slavery is. I understand how it works. And like Mr. Channing said, see, when he comprised all of his works into volumes, this is what he said: books which are to pass away may yet render much service by their fitness to the intellectual struggles and moral aspiration of the times in which they are written. If in this or in any way I can serve the cause of truth, humanity, and religion, I shall regard my labors as having earned the best recompense which God bestows on his creatures. And I have a lot of respect for Mr. Channing. He was a smart man. He really was. And Frederick Douglass, at the end of his book, he pointed out, let me read you this. I have written out of my experience here, not to exhibit my wounds and bruises, to awaken and attract sympathy to myself personally, but as a part of the history of a profoundly interesting period in American life and progress. I have meant it to be a small individual contribution to the sum of knowledge of this special period, to be handed down to after-coming generations which may want to know what things were allowed and what prohibited, what moral, social, and political relations subsisted between the different varieties of the American people down to the last quarter of the 19th century, and by what means they were modified and changed. The time is at hand when the last American slave and the last American slaveholder will disappear behind the curtain which separates the living from the dead, and when neither master nor slave will be left to tell the story of their respective relations and what happened in those relations to either. My part has been to tell the story of the slave, the story of the master, never wanted for narrators. They have had all the talent and genius that wealth and influence could command to tell their story. And boy, ain't that the truth. Whoever commands the labor of millions and millions of people, that political authority, you're going to hear their arguments over and over again. Their arguments are going to be abundant because they have wealth and power. You're not going to really hear the arguments of the slave. They'll keep them suppressed. Okay, now Hinton Helper, this is one interesting thing he pointed out back then, okay, about the condition of the non-slaveholding whites as well as the black people. This is what he said in his book he wrote in 1856, The Liberation of 5 Million Poor White Trash from the second degree of slavery and of 3 million of miserable kidnapped Negroes from the first degree cannot be accomplished too soon. Yeah, you see, that's one thing I found interesting about that period. And Frederick Douglass saw the same thing, is that the non-slaveholding whites were really not in any better position than the Negroes. See, the slaveholders, they only represented about 3% of the population, but they controlled everything. Yeah, they were your governors, your representatives in the state legislatures, the judges, the sheriffs. They controlled all the newspapers, they controlled the educational systems, they were the preachers in your churches. In other words, everything in your mind was fed from the cradle to the grave. They controlled it. They did. They sure did. And what Helper pointed out too is that, the non-slaveholding whites, their labor was only compensated to such a degree to where they could just live. They couldn't accumulate anything. They weren't able to save any money. It's like Helper pointed out, rarely would you find a non-slaveholding white that was able to save up to $5 back then, which was, $5 was a pretty good amount of money back then. But the non-slaveholding whites, they were kept poor all their lives. And the slaveholders did that on purpose. That way they could never rise up and compete with them. Yeah, okay. Now, what Lincoln pointed out in his re-election in 1864 was pretty interesting too. And let me share this with you. Okay, and this is a speech he gave on the 10th of November, 1864, just a few days after he was re-elected. If the loyal people, united, were put to the utmost of their strength by the rebellion, must they not fail when divided and partially paralyzed by a political war among themselves? But the election was a necessity. We cannot have free government without elections. And if the rebellion could force us to forego or postpone a national election, it might fairly claim to have already conquered and ruined us. The strife of the election is but human nature, practically applied to the facts of the case. What has occurred in this case must ever recur in similar cases. Human nature will not change. In any future great national trial compared with the men of this, we shall have as weak and as strong, as silly and as wise, as bad and as good. And that's true. That's true. So if slavery should start to rear its ugly head again, we're going to see similar arguments. It's going to be similar. And I'll tell you, the people that argue in favor of power over the labor of human beings, they're hateful, man. They were hateful back then. And quite frankly, they're hateful today. I mean, you dare argue against their tax system that takes our wages away from us? Well, they get mad at you. I've been called all kinds of nasty names. Trying to cite my authorities and, show them that what you're doing violates the 13th Amendment. I mean, there's one website out there called Quatloos. They're supposed to be tax experts. And man, they told me that, we found that the slavery arguments are some of the dumbest of the many dumb arguments made by the tax protesters. And they just lash out at you, call you stupid. And if you don't like it, just pack your stuff and get out of this country and move to Haiti. That's the way these people are, man. They're hateful. They're very hateful. Okay, but anyway, what is it that causes someone to have the status of slavery attached to them? Let's examine this, all right? Now, one thing we have to realize about slavery, all slavery, I don't care what form it is, it always has a force of law behind it. You know, statutory enactments upheld by judicial decisions. This is Justice Curtis, and this comes out of the Dred Scott decision, which was decided in the 1856 term of the Supreme Court. Slavery, being contrary to natural right, is created only by municipal law. This is not only plain in itself and agreed by all writers on the subject, but is inferable from the Constitution and has been explicitly declared by this court. The Constitution refers to slaves as persons held to service in one state under the laws thereof. Yeah, the state of slavery is deemed to be a mere municipal regulation founded on and limited to the range of territorial laws. You can go way back to the Mansfield case in England. I think that was back in the 1700s, where Lord Mansfield, that's what he said. The law is what slavery is for, always has, always will. But anyway, the status of slavery. Let's see what Justice Curtis said about the status of slavery. Okay? He said the status of slavery embraces every condition, from that in which the slave is known to the law simply as a chattel with no civil rights, to that in which he's recognized as a person for all purposes, save the compulsory power of directing and receiving the fruits of his labor. Yeah, directing and receiving the fruits of his labor. It doesn't matter whether you're a chattel slave or whether you're just out there working for a living and somebody's able to reach out and grab power over your labor and take whatever they want from you. It doesn't matter. It imposes the status of slavery. Now, this is a book I wrote, and you can order this off my website, The Slaveholders Won the Civil War. Just click on the picture of Ulysses S. Grant and General Lee, and you can buy it. You'll have to use PayPal because I haven't got it set up to just regular take your credit cards yet. Okay? But a man who lived through the Civil War, this is the very beginning of chapter 1, Robert Ingersoll. He was a preacher, commander of the 11th Regiment of the Illinois Volunteer Cavalry, and he was a Attorney General of Illinois back then, after the war. That's what he said. After the Revolution, principle was sacrificed for the sake of gain. The Constitution contradicted the Declaration. Liberty as a principle was held in contempt. Slavery took possession of the government. Slavery made the laws, corrupted courts, dominated presidents, and demoralized the people. Slavery was the cause of the war, and slavery was the perpetual stumbling block. Yes, slavery did cause that war, people. It sure did. Okay? And another thing, too, let me point this out, what it means to direct and receive the fruits of your labor. Okay, let's see what Representative Ignatius Donnelly of Minnesota said on the floor of the House of Representatives, February 1st, 1866. He said, slavery consists in a deprivation of natural rights. A man may be a slave for a term of years as fully as though he were held for life. And listen to this. He may be a slave when deprived of a portion of the wages of his labor as fully as if deprived of all. Let me repeat that. He may be a slave when deprived of a portion of the wages of his labor as fully as if deprived of all. Did you listen to that? Okay. Now, after the Civil War was over, all right, we had a free labor market. In other words, you were able to go out and find work, contract your labor for the highest wages you could get, and you'd receive those wages in full. And you'd pay your taxes indirectly when you spent your money as a consumer. And that free labor system lasted all the way up till Roosevelt and his New Deal. Okay, remember I mentioned that in some other videos. Roosevelt and his New Deal changed all that. Okay? When he signed the Social Security Act into law in 1935, the taxation pursuant to that Social Security Act started taxing people's wages at 1%. 1% in 1937. And that was reported as something that was brand new and had never been done before in the history of the country. Okay? And that Social Security tax was supposed to increase at 0.5% increments every 3 years till it peaked at 3% in 1949. That's all it was supposed to cost to provide Social Security. Didn't work, did it? Didn't work. Then you had the 5% victory tax, which was a result of the 1942 revenue law. This was a 5% tax on people's wages, and it was an emergency tax to help support the war. And according to the 1942 revenue law, which I was able to find in the statutes at large and copy and study for myself, it says right there in the law that when hostilities in the war are declared over with, that tax was supposed to cease. Well, Truman declared hostilities in World War II over with in 1946. They never stopped the tax. They kept it going. They lied. Again, imagine that, they lied. But it was reported, I think it was either in Newsweek or Time back then, that the 5% victory tax had no parallel in U.S. tax history. There again, it was a direct tax on the wages of the people across the board, across the whole country. It had never been done before in the history of the country. And let me share something with you. This is a case from back in 1920. It's called Eisner versus Macumber. Okay? And it goes into detail about the income tax, the 16th Amendment. Remember, the income tax started in 1913 with the 16th Amendment. And the court said, and these are the high points of the case right in the very beginning. Okay? Constitutional Amendment 16 did not extend the taxing powers to new subjects, yet conferred no new taxing power on Congress, but merely removed the necessity which otherwise might exist for an apportionment among the states of taxes laid on income. See, that's all the 16th Amendment did, folks. See, the Supreme Court in a case called Pollock versus Farmers Loan and Trust back in 1894 or 5, something like that. See, they tried to impose an income tax back then without amending the Constitution. But the Supreme Court said, no, you can't do that. They didn't say you couldn't impose the income tax, but they ruled that it was a direct tax and therefore had to be subject, according to the Constitution, by the rules of apportionment. They had to apportion the tax among the states. Well, the politicians in the federal government didn't like that. They wanted to treat it as an indirect tax so the money could come straight into the Treasury so they could spend it in any way they saw fit. So all the amendment did is say, even though the income tax is a direct tax, we are going to treat it as an indirect tax so we can just bring the money straight into the Treasury and not have to apportion it among the states. You see how that works? That's all that 16th Amendment did. It didn't give the federal government any new taxing powers. And when the Social Security Act started taxing wages in 1937, and the victory tax wages in 1942, in the press, it was reported in the press that these were brand new taxes that had never been imposed before in the history of the United States. They were brand new. And in Eisner, they said the 16th Amendment did not confer any taxing powers. You get it? And to this day, I have not found where the Supreme Court has ruled on the constitutionality of taxing people's wages. Don't you find that kind of strange? It's kind of strange. So what I did, I methodically went through the Supreme Court reporters. This was back in the 90s. So you can research the Supreme Court cases today online, on the internet. But back then you had to go to the law library and go through the volumes. And I did that. I went through the volumes of Supreme Court reporters from 1914 all the way as far as I could up to that time. And I think that was in 1995 or 6. And I looked for all the cases under United States versus an individual or vice versa. So I wasn't concerned about, corporations and businesses, because that's what the income tax was designed to do, is tax the gains and profits of business activity. See, and that's one thing they pointed out in the Eisner case. Okay, what income is. They had to, emphatically try to tell people this is what income is. All right? The government, although basing its argument upon the definition as quoted, placed chief emphasis on the word gain, which was extended to include a variety of meanings, while the significance of the next three words was either overlooked or misconceived. Derived from capital, the gain derived from capital, etc. Here we have the essential matter, not a gain accruing to capital, not a growth or increment of value in the investment, but a gain, a profit, something of exchangeable value proceeding from the property, severed from the capital, however invested or employed, and coming in on by the recipient, the taxpayer, for his separate use, benefit, and disposal. That is income derived from property. Nothing else answers the description. Yeah, there's got to be a gain, there's got to be a profit. And we can see that even further. Let's go back in time to 1861 and 62. That's really when the income tax did start. The income tax was an emergency tax to help support the Civil War. Okay? Now, let's see here. April 3rd, 1862. Okay, and this is Representative Stevens. He says the words gain and income mean the same thing. They're equivalent terms. They mean the net profits. You cannot have any gains until you pay the expenses. What it costs to produce is to be deducted, and then there will be only left the net profits. I mean, nowhere can you find where, back in those days, wages were associated with income. You can search in vain for it. You won't find it. Okay, here's the Senate, July 29th, 1861. Okay, and Senator Simmons gives an example. Okay, if a man has $100,000 with 6% stock, he would only have to pay a $150 tax on the income. That is 2.5% on the $6,000. Say the income's at $6,000. That's the 6% of the $100,000. See, the stock gain value. The gain in the value of the stock was $6,000. That is the income. That's what could be taxed. Are you understanding where I'm coming from? That's what the income tax was all about, folks. That's what it wasn't designed to tax people's labor or their wages. I found that out by doing this research. They've perverted the thing. It's been perverted into something it was never intended to be. So I methodically go through the Supreme Court reporters looking for the case where there's a wage earner standing before the court. And I figured, well, probably what I'll find is somebody that got criminally charged for not paying their taxes, and the appeal made it up to the Supreme Court. Sure enough, that's what it was. But you know how long it took to find it? The 1991 term of the Supreme Court. In other words, the income starts in 1913 with the 16th Amendment, and it takes almost 80 years before I find this case. Almost 80 years. Now you would think if they had the constitutional authority to tax your wages, a case like this would have shown up way before then, wouldn't you? And then listen to what they say, and these are one of the high points. This is one of the high points of the case. Number 6, where possible, courts interpret congressional enactments so as to avoid raising serious constitutional questions. Gosh, I wonder what the serious constitutional questions are. See, this fellow Cheek was an airline pilot, and no doubt his wages are way up there. He was at the top of the wage earning scale. But he was involved with a group of people that were doing all this research, and he quit filing and paying his taxes for a while. You know, because he took the position that the law he wasn't legally obligated to do so. But the thing is, Cheek and the people that were associated with him, that were the study group, they never argued slavery. They argued stuff like the 16th Amendment wasn't properly ratified. They argued, you know, the Federal Reserve notes don't constitute money because, you know, it's not backed by gold and silver and stuff like that. They never argued slavery. Okay? But there's some interesting points in this case. Okay? And let me see. Yeah, there's some, you see, you find little tidbits in these cases if you look. See, wages are not income within the legal sense of the term. Now let me explain this to you, okay? Anybody that has any knowledge of the law should know this. If you're a lawyer, you should know this. You take a law dictionary and a standard dictionary. They're two different animals. Okay, a law dictionary, when it defines a word, it's restricted to its application in the law. That's it. It doesn't go beyond that. Whereas the same definition of a word in a standard dictionary could encompass a lot more things. For example, let's take the word bar. Bar. Look up the word bar in a law dictionary. Well, it means a particular part of a courtroom. In other words, if you're arguing your case in court, you're standing before the bar. But the legal definition of bar does not encompass an iron rod, or the legal definition of bar does not encompass a drinking establishment. Yeah, I mean, arguing your case in court can get pretty damn stressful. And since I'm standing before the bar, Your Honor, since I'm standing before the bar, I mean, could you make me a a double shot of Jack Daniels on the rocks. I need to calm my nerves, man. No, he'd probably hold you in contempt for that. See, the legal definition of the word bar does not include a drinking establishment or an iron rod. And the same is true with the legal definition of the word income. The legal definition of the word income is restricted to the gains and profits of business activity, not the laborer's bread, not wages. And they know it. Let me show you this, okay? Here's a little quote from the Cheek case. You see, they reversed Cheek's conviction on the statutory ground of willfulness, that he didn't act willfully. We'll get into that in a minute too. Of course, in deciding whether to credit Cheek's good faith belief, the jury would be free to consider any admissible evidence from any source showing that Cheek was aware of his duty to file a return and, listen to this, to treat wages as income. Notice that? The court said to treat wages as income. The court didn't say wages are income, did they? But it's his duty to treat wages as income. Yeah. Yeah, they know. They know. See, here's another one. Okay? It was therefore error to instruct the jury to disregard evidence of Cheek's understanding that within the meaning of the tax laws, he was not a person required to file a return or pay income taxes, and that wages are not taxable income. Listen to this. As incredible as such misunderstandings and beliefs about the law might be. See, they didn't say about how incredible as such misunderstandings and beliefs of the law are. No, they said might be. They know. They know. Folks, they know. Jeez. Anyway, let me read one little more excerpt from this. Of course, Cheek was free in this very case to present his claims of invalidity and have them adjudicated. But like defendants in criminal cases and other contexts who willfully refuse to comply with the duties placed upon them by the law, he must take the risk of being wrong. Well, I would disagree with that. I really would. You know, if a judge has no respect for the truth, it really doesn't matter what your legal arguments are. Your legal arguments could be 100% rooted in the truth, but if the judge has no respect for the truth, you can forget it. They're not going to rule in your favor. And that's the problem we have today. It is. Okay, now one other thing I want to share with you is an old maxim that pertains to slavery, that's always attached to slavery. Let me read you this. This comes from the Dred Scott decision again, 1856 term of the Supreme Court. If in Missouri the plaintiff were held to be a slave, the validity and operation of his contract of marriage must be denied. The status of slavery bastardizes marriage. He can have no legal rights, of course, not those of a husband and father, and the same is true of his wife and children. The denial of his rights is a denial of theirs, so that, though lawfully married in the territory, when they came out of it into the state of Missouri, they were no longer husband and wife, and a child of that lawful marriage, though born under the same dominion where its parents contracted a lawful marriage, is not the fruit of that marriage, nor the child of its father, but subject to the maxim, partus sequitur ventrum. I don't know if I pronounced the Latin right. Partus sequitur ventrum. Drill that into your head. Drill it into your head, because I'm going to show you how it applies today. I'm going to explain this to you. Because you see, whenever I studied cases like this, and when I studied that case back in the 90s, I said, well, I've never seen that maxim before. So I get out my 1940 Bouvier's Law Dictionary under maxims, and I find it. Partus sequitur ventrum means the offspring follows a condition of the mother. It's only logical. In other words, whatever condition of slavery or servitude mommy is in, well, the kid's going to follow that condition. It's just logical. See, back in Civil War time, pre-Civil War times, okay, mommy was a slave in bondage. So mommy has a child. The child's going to follow that condition. Going to be a slave in bondage. Yeah, that's just the way it is. Now today, remember the first law, I just told you that not too long ago, the first law that started taxing your wages, the Social Security Act of 1935. Now, when that law took effect, before you could get paid for working, you had to get a Social Security number. In other words, you didn't have to get the number back then until you went to work. Okay? It wasn't imposed on you before then. But then slowly over time, okay, this is what they've done. I remember back in the early 70s. See, I went to, one of my classes in high school was agriculture. I took agriculture. Franklin High School, Mr. Prophet was a teacher, Mr. Prophet and Mr. Corbin. One day, this is when I was a freshman, one day Mr. Prophet asked the class, boys, how many of y'all don't have no Social Security number? Well, most people raise their hand. Well, boys, y'all need to get you a Social Security number. And he brought all the forms out and helped people fill it out, figure out how to fill it out, and sent them off. About a month later or so, he walked through the class all proud, handing us our Social Security cards. Well, we didn't think nothing of it. We just thought it was something we had to do. But then it got into the 80s. You want to claim your kid as a tax exemption on your taxes? Well, you got to get it a Social Security number. Now today, they just impose a number of birth. Just automatic. Child born, there's the number. Partis sequitur ventrum, you see it? The income tax was never designed to determine the allowance the worker received from their labor. It's a perversion of law. It's the grossest perversion of law in the history of this nation, what they've done. What they've done is really nothing short of treason. But once again, they're laying claim upon the labor of children when they're born. See, since mommy's labor is subject to wage taxation and garnishment for punishment if she's disobedient, the child's going to follow the condition, her condition. The maxim applies again, doesn't it? That make you feel all warm and fuzzy inside? Anyway, old Abe Lincoln, when he was in the debates with Stephen Douglas, made a very true comment. Very true comment. Let me share this with you. This shouldn't surprise us, folks. What's happening to us should not surprise us at all. Listen to what Lincoln said in 1858. That is the real issue. That is the issue that will continue in this country when these poor tongues of Judge Douglas and myself shall be silent. It is the eternal struggle between these two principles, right and wrong, throughout the world. They are the two principles that have stood face to face from the beginning of time and will ever continue to struggle. The one is the common right of humanity, and the other, the divine right of kings. It is the same principle in whatever shape it develops itself. It is the same spirit that says, you toil and work and earn bread, and I'll eat it. No matter in what shape it comes, whether from the mouth of a king who seeks to bestride the people of his own nation and live by the fruit of their labor, or from one race of men as an apology for enslaving another race, it is the same tyrannical principle. And Lincoln also pointed out, if the country's going to lose liberty, be the last to desert. I'm not deserting people. I think we still might have some time to fix this. And Lincoln also said, when people realize that things are all messed up, you need to raise a warning voice to returning despotism. That's what I'm doing. That's what I'm doing. But anyway, folks, like old Mark Twain said, history might always not repeat itself exactly, but it sometimes does rhyme. And those of us who are not willing to learn history are doomed to repeat the mistakes of history. If you don't learn your history, you're doomed to repeat it. And folks, I'm telling you, you need to stop this direct taxation upon your labor. The government can gather in all the revenue they want, all the tax money they want by taxing people indirectly as consumers. There's absolutely no reason whatsoever to directly tax your labor. The only reason they want to tax your labor is for the purposes of control. Like Justice Douglas pointed out in Murdoch versus Pennsylvania years ago. The power to tax a privilege or a right confers the power to control or suppress its enjoyment. Yet the power to tax gives the power of control. And like way back in the 1830s, I believe it was, Justice Marshall said the power to tax involves the power to destroy. Yeah. Oh yeah. And they'll argue that, oh, taxing your wages doesn't impose the status of slavery on you. There's a bunch of bull, people. Whoever determines your allowance from labor is your master, and you're that person's slave. That's just the way it is. Douglas would tell you that. It was common practice back in pre-Civil War times. Slaves that were trustworthy, like him, yeah, their masters would let them go out and live on their own. Find their own work, they could contract their own labor, get paid their wages would come to them. But for the privilege, they had to give the master an allowance from those wages. Douglas had to pay Master Hugh $3 a week. He made $6 to $10 a week as a caulker in shipbuilding. That's been back when they built wooden ships. You know, he was in Baltimore. And he was good at his trade too, but he had to pay Master Hugh $3 a week. In other words, if Douglas made about, I'll say he made about $8 a week, he had to pay Master Hugh what? That's around roughly 30% income tax. See, the slaveholders had income tax on their slaves. Nothing new about it, people. There's nothing new about it. But I've given you something new to think about. And if you want to buy my book and read it, like I say, just click on the picture of Mr. Ulysses Grant and anyway, order it. You know, Ulysses Grant, Robert E. Lee, just click on it and order it. And it'll teach you a lot. It'll teach you a lot of stuff you probably don't know. But to conclude this remembrance on the Civil War, remembering the Civil War, let me share this with you. And this comes from November 21st, 1864, a letter Abraham Lincoln wrote to a lady named Miss Bixby of Boston, Massachusetts. Dear Madam, I have been shown in the files of the War Department a statement of the Adjutant General of Massachusetts that you are the mother of 5 sons who have died gloriously on the field of battle. I feel how weak and fruitless must be any words of mine which should attempt to beguile you from the grief of a loss so overwhelming. But I cannot refrain from tendering to you the consolation that may be found in the thanks of the Republic they died to save. I pray that our Heavenly Father may assuage the anguish of your bereavement and leave you only the cherished memory of the loved and lost, and the solemn pride that must be yours to have laid so costly a sacrifice on the altar of freedom. Yours very sincerely and respectfully, Abraham Lincoln. And I'll conclude this remembering the Civil War with a song from back then. It's called Somebody's Darling. Anyway, folks, this is serious. This is really serious. You need to make Mr. Trump the nominee for the Republican Party, and next year you need to elect him. Believe me, folks, you need to. This is the most important election that we've had since 1860, and now you know why.
Into the world of the clean whitewashed halls, where the dead slept and the dying lay, wounded by bayonets, sabers, and bows, somebody's darling was born one day. Somebody's darling, so young and so brave, wearing still on his sweet yet pale face, soon to be hid in the dust of the grave, the lingering light of his boyhood's grace. Somebody's darling, somebody's pride, who'll tell his mother where her boy died. Matted and damp are his tresses of gold, kissing the snow of that fair young brow. Pale are the lips of most delicate mold, Somebody's darling is dying now. Back from his beautiful purple-veined brow, brush off the wandering waves of gold. Cross his white hands on his broad bosom now. Somebody's darling is still and cold. Somebody's darling, somebody's bride, who'll tell his mother where her boy died. Give him a kiss, but for somebody's sake, murmur a prayer for him soft and low. One little curl from his golden mats take. Somebody's pride they were once, you know. Somebody's warm hand has oft rested there. Was it a mother so soft and white, or have the lips of a sister so fair ever been bathed in their waves of light? Somebody's darling, somebody's bride, who'll tell his mother where her boy died? Somebody's watching and waiting for him, yearning to hold him again to her breast. Yet there he lies with his blue eyes so dim, and purple childlike lips half apart. Tenderly bury the fair unknown dead, passing to drop on his grave a tear. Carve on the wooden slab over his head. Somebody's darling is slumbering here. Somebody's darling, somebody's bride, who'll tell his mother where her boy died.